Hello, Michigan Realtors, and welcome back to Season 3 of Letter of the Law. It has been a long time coming, and we are excited to get back to producing videos like this on a more regular basis. Now remember, we draw our topics for these videos from your feedback, so please let us know if there are subjects that you would like us to cover. Now today's segment will address various issues that arise when your buyer client becomes interested in a home that is a for sale by owner or is otherwise not listed for sale. With limited inventory, this issue and how best to deal with it has been coming up more and more. Often, a realtor's immediate reaction is that there needs to be some type of dual agency relationship set up. This is simply not true and is often not the best course of action. Now, a realtor faced with this situation should start by reviewing their own buyer agency contract. Some buyer agency contracts require the buyer to pay a stated commission to the buyer's broker and provide for a credit to the extent that the buyer's broker is paid by the listing broker. If this is the case, then the buyer's broker does not need any contract with the FSBO seller. The buyer can simply include a provision in the purchase agreement requiring the seller to pay the buyer's broker on the buyer's behalf. Now, realtors should keep in mind that the only time a commission obligation should be dealt with in this purchase agreement is when the buyer is obligated to pay the buyer's broker and the buyer wants to pass on that obligation to the seller. In this instance, the seller's contractual obligation is to the buyer, who is a party to the purchase agreement, and who in turn is contractually obligated to the buyer's broker via the buyer-broker contract. If, on the other hand, the buyer is not contractually obligated to pay the buyer's broker, then the buyer's broker will want the seller to agree to pay a commission if their buyer client purchases the seller's home. This will require a separate contract between the seller and the buyer's broker. However, it is not necessary to create any agency relationship with the seller. Instead, the seller can acknowledge that the buyer's agent is only representing the buyer, but agree to pay the buyer's broker a commission in the event of a successful sale. This type of agreement is commonly referred to as a one-party commission agreement rather than a one-party listing agreement. Now, as an aside, it is certainly the case that a one-party listing agreement can be used in this scenario, but of course, the realtor must then act as a consensual dual agent. Most realtors, and probably all lawyers, would agree that a single agency arrangement is far less risky than a dual agency arrangement. However the agency relationship is structured, realtors need to make sure that from the very beginning, everyone in the transaction clearly understands the agency relationships involved. Under Michigan law, agency disclosure must take place prior to the disclosure of any confidential information. If a buyer's agent will be talking directly to the sellers about the sale of their home, the buyer's agent is going to want to make this disclosure very early on in the conversation. Once agency status is established, a realtor must be very careful to work consistently within that framework. An unknowledgeable and inexperienced seller is likely to look to the realtor for guidance, even where the realtor represents the buyer. FSBO sellers should be encouraged to hire an attorney to assist them in negotiating a purchase agreement and closing the sale. If the FSBO seller chooses not to have an attorney, then the realtor must be very careful when interacting directly with the seller so as not to create the appearance of an agency relationship. If through their interactions with a buyer's agent, a seller comes to believe that the agent is representing the seller's interests, the buyer's agent may have inadvertently created an agency relationship with the seller. Now at that point, there would be a non-consensual dual agency situation, and the buyer's broker will have forfeited its right to a commission. Now I know you've heard this before, but when presenting an offer to a FSBO seller, a buyer's agent should never advise the seller as to the wisdom or reasonableness of a particular provision. A FSBO seller should never be told that a particular clause is just boilerplate or that something is always done this way. While such statements may be viewed as nothing more than persuasive argument where the seller is working with a listing agent who can offer his or her own opinion on such, the statements may be deemed misleading and overreaching where the seller is unrepresented. Now, what if the seller finds the offer to be unacceptable and asks the buyer's agent to help the seller prepare a counteroffer? It is probably fairly easy to prepare a counteroffer at a seller's dictated price without overreaching, or creating the appearance of an agency relationship. But what if the seller wants you to prepare an addendum dealing with post-closing occupancy responsibilities? What if the seller wants to treat your buyer's offer as a backup offer? The farther you stray from the standard form, the more difficult it will be for you to prepare clauses dictated by the seller without appearing to be working for the seller. Now, in many instances, it may be advisable to take the seller's verbal requests back to your buyer client and use that information to prepare a new offer on behalf of your buyer client. Using this approach may make it more readily apparent that you are preparing the revised offer as the buyer's representative. Now, of course, as Realtors are well aware, the work is not done once the purchase agreement is signed. Realtors working with FSBOs often express frustration at the fact that they must do the work of two agents. Of course, the simple fact is that the transaction must move forward, and the Realtor is typically the only person involved that knows how to get this done. Again, Realtors working with FSBOs as buyer's agents should assist the seller in ministerial manners only. While it is perfectly appropriate for a buyer's agent to order the title insurance on the seller's behalf, it is not appropriate, for example, for a buyer's agent to advise the seller as to inspection contingency concessions or disclosure requirements. As always, thank you for tuning in for this new season of Letter of the Law. If you have questions or suggestions for new topics, please send them to the email listed below. And as the kids say, don't forget to subscribe to this YouTube channel to remain up to date on Michigan Realtors legal and government affairs video content. Thanks for watching, and we'll see you next time.